feel that a chief minister of a state is the chief minister of the entire state. He is the chief minister of every last citizen of the state, and not a chief minister of X or Y or Z or a majority or a minority or anything. He very pejorative, very denigratory statements made against Lord Mias. He also asserted that there were some Hindus who were forcefully converted to Islam during the Mughal period.
I remember to have seen that letter and wrote my comment on that also, that nothing prevents the petitioners from approaching the appropriate forum, either filing writ petition or filing whatever.
Deeply obliged. I just needed to.
That was immediately responded to, but it appears you have not been told about that.
No, we didn't know, but that's why we moved the Honorable Supreme Court, and the Supreme Court asked us to come before your lordships, gave us liberty to come before your lordships, and that is how we are here.
That's right. There was a letter of request which I distinctly remember to have disposed of. I mean, wrote my comment on it.
But that may have such a huge amount of probably correspondence in the High Court and judicial matters, etc. That probably maybe
the correspondence. I mean, that one correspondence would be important for the person who has made it. So that was immediately taken note of.
No, we have no grievance at all on that. We just wanted to point out as a matter of disclosure that we had made an effort. The learned Honorable the Chief Justice of India told us that, look, there's a difference between an appeal for suo motu action and a direct writ petition. So why don't you adopt the direct means of going by way of a writ petition? Orally, it fell from the court. And then it's a point well taken, because suo motu is a very rarely exercised jurisdiction. It's not every day that the courts would exercise suo motu powers. So having said that, I would just like to join Dr. Singhvi in saying that unfortunately, and it's with great anguish that these petitioners, at least, who are not politicians, who are not people who have anything to do with one side or the other as far as the political battle lines and so on are drawn, it's with great anguish they come before the court, because they feel that a chief minister of a state is the chief minister of the entire state. He is the chief minister of every last citizen of the state, and not a chief minister of X or Y or Z or a majority or a minority or anything. He, after all, he is the go-to person for the entire state. When he gets elected and when he swears his oath of office, he is there to represent everybody without fear or favor, without discrimination, without anything. And this is the anguish which brings these three petitioners before your lordship, that they feel that a consistent course of conduct, the respondent number 3 in our case, has been sort of, for whatever reasons it may be, but playing one side against the other and so on, and leading to a very vociferous and a very disruptive or a demeaning sort of situation in the state, and which reflects on the entire state. It doesn't reflect on the minority. Ultimately, every such thing reflects on the entire, what we in North India would call the mahal of the state. Ultimately, it denigrates everybody, not X or Y or Z. Having said that, I would just flag that right from 2023, as we have set out at page 16, 23rd June 23, then on 13 July 23 at page 121. I won't read these letters, but if I can just flag them, there are various very pejorative, very denigratory statements made against Mias. The constant refrain has been Mia Muslims are somehow bringing the state down and so on and so forth. So I would just ask your lordship to just make a note of it. Page 116, page 121, page 127, and page 131. 116, 121, 127, and 131. 142 is one of the documents which Dr. Singhvi showed your lordship, which happened in Chhattisgarh. Now, my lords, if your lordships come straight away to 8th of February 2024, which is, my lords, an address to the Legislative Assembly of the state, on 8th of February 24, in the context of a scheme known as the Mission Basundara scheme. And in the context of a scheme of the government, which is meant for all the people of the government, the statements made, that page 146, if my lords are kind enough to come to Annexure 12. Now, here is a very welfare scheme, very well-meaning scheme which is introduced. And this is the report with regard to what is stated. You people can claim to be indigenous if you show your document or identify before you were converted, then you too will get indigenous status, said the Assam CM in the State Assembly.
Yes.
If you convert, then you will get indigenous status. Assam Chief Minister, Honorable Mr. Sharma, said on Thursday that the person can claim to be indigenous if they show their document or identity before conversion. He was sharing insight on Mission Basundara in the State Assembly. You people can claim to be indigenous if you show your document or identity. He also asserted that there were some Hindus who were forcefully converted to Islam during the Mughal period. He gave an option and said that these people could return to their originality by accepting Hinduism again, thereby getting their indigenous status back. While on Thursday, the CM was talking about the land allotment and patta distribution to indigenous people of Assam, he cited the definition of indigenous: people who live in a place for years and years are the indigenous people. Aboriginals are the indigenous people. As we say, Red Indians are the indigenous people in America. In this context, he said that anyone coming and settling down in Assam from outside Assam can't be called indigenous. Replying to a counter question of opposition MLAs over the Mia, the Bengali-speaking Bangladesh origin Muslim not getting patta, the CM reacted that Mias came recently, adding even people came to this land Assam 100 years back can't be said as indigenous. He categorically said Basundara is not for the migrant Muslim. He stated that for the people who came to Assam from other parts of the country, there'll be another process. Now, I must explain to your lordships and lords, that this Bangladesh is an issue which is used, unfortunately, very often as a dog whistle. And the reason goes that there's a very deep and old fault line in the state of Assam, and it's a genuine grievance with the people of Assam I've had for some 200 odd years. When during the British era, some large-scale settlements were permitted, and when the settlement of low-lying lands was given to people from Bengal, that was the unified Bengal of India. And because there was a fair amount of large-scale settlement of Bengali origin people in those days, and when I talk about Bengali origin, not Bangladeshi origin, but Bengali origin in the 19th century, 1860, 1850, 1870, etc., these have all been written about a great deal in Assamese history and all. So there was an ethnic and linguistic grievance, and legitimately so, of people. It was never a religious grievance. It was always an ethnic and a linguistic grievance, because they felt that the British have imposed people from a different culture or different linguistic background on the state of Assam.
Yes. Yes.
Now, when the chief minister of the state says even a person who came 100 years ago cannot be considered as indigenous, he is flagging that sense of grievance, because 100 years ago, India was a unified country. 100 years ago, there was no Bangladesh. And Bangladeshis who entered after 25th of March 1971 are definitely outside the pale. They are not entitled to any protections. Your Lordship's Court and the Supreme Court have made it very clear that those who came afterwards will be treated as illegal migrants. But those who came before that, those who came in 1860, those who came in 1920, 1930s, again, the British had a wave of some settlement in 1920s and 30s. Now, to treat them, and they are the people who are called Mias. Bangladesh is only a dog whistle. All Bengali-speaking and Bengali origin Muslims are called Mias. The Bengali origin Hindus are not called Mias. They also may not be accepted as on the same par with others, but they are not called Mias. Are only Bengali origin Muslims. So I just wanted to flag this to your lordship, because there's a certain historical background, and my Lord Honorable Justice Chaudhary would be very familiar with that, because your lordships have seen this culture throughout your lordship's life. Now, so when these statements are made on a welfare scheme, then this gives your lordship a bit of a background of how this happens. Then your lordship will see on 6th of June 2024 at page 150, statements made in regard to the loss of elections in 3 neighboring states. And the statements made there are to the effect that we have lost these elections because of a particular religious denomination. I'm not flagging these to your lordships as something which is actionable today. I'm only giving your lordship, when I come to today's act, I think please see it in this background of consistently. Now, my lords, at page 161, there was a severe flooding in the city of Guwahati, in the area of Guwahati in August of 2024. And at 161, your lordship will see that following that severe flooding, the respondent number 3 made a statement attributing the entire flooding to a college on the border of Meghalaya, and that college has been established by a person who belongs to the minority community. And this entire statement was to the effect that there is a land jihad, there is a jihad started by a promoter of a university, and just as there is land jihad, he has started a flood jihad against Assam. And this at page 161, my lords will find at 162, my lords may just see, about para 4, Sharma has pointed to deforestation in the hills in the area as the reason behind the flood, but singled out the institute, accusing it of jihad. He pointed to the ongoing construction work and the work in the campus of a medical college. I think that the USTM owner has started a jihad. We talk about land jihad. He has started a flood jihad against Assam. Otherwise, no one can cut hills in such a ruthless way. He went on, no one who loves nature, especially an education institution, can cut it. I have to call it a jihad. I believe it is deliberate. Otherwise, they can call an architect, etc. And then he says in the second last paragraph, from tomorrow, if the students from Guwahati stop studying and Guwahati's teachers stop going there, then Guwahati's floods will stop. I have given a letter to the Meghalaya CM. I will meet him too, but I don't know how much they can do, but because the damage has been done, etc. Then your lordship will come to the next 13th of August, a further escalation in this war of words against a university at page 169. On 13th August, after the flash flood was blamed on this university, now he said that they have created a Mecca over there because they've got 3 domes on a gate and you have to enter through Mecca to go there. And at page 170, your lordship will just see the top question by reporters on his use of the term jihad. He said, they are doing jihador bap, the father of jihad. I'm being mild by calling it jihad. It is destroying our education system. Whatever attacks our civilization, our culture, that is called jihad. So even the medical college is said to be destroying our educational culture and our system, etc. Then my lords would see that on page 173, a journalist was attacked on the ground of his religion. And then, my lords, on page 183, again during the Legislative Assembly proceedings, at page 183, my lords, on 27th of August 2024, the Honorable CM categorically said that I will openly say that I am against them. Just see 183, my lords. This is in Assembly. Chief Minister Himanta Biswa Sharma on Tuesday said that he would take sides and won't let Mia Muslims take over Assam. Mr. Sharma was speaking in the Assembly on an adjournment motion brought on law and order issues relating to some rape of a child, a 14-year-old girl. Replying to the motion, he said crime has not increased if the population growth is taken into account. When the opposition charged him of being partisan, Mr. Sharma resorted, I will take sides. What can you do about it? Why will people from lower Assam go to upper Assam so that Mia Muslims can take over Assam? We won't let it happen here, certainly. Now, in this background, and there are several more, but I want to come to today, what is happening since January of this year is very incendiary. It is not just hate speech, but it is incendiary speech, which is aimed at setting a fire and causing disruption in the ordinary harmony between human beings, which is required, which a chief minister should be fostering. So please come now to the current year, my at page 192, your lordship will see on 25th of January 2026, with regard to the summary revision of electoral rolls, the chief minister stated that notices are being served only on Mias and not on Hindus. And the revision. So, Lordship will see this report and scroll. Assam Chief Minister Himanta Biswa Sharma said on Saturday that only Mias and not Hindus or Assamese Muslims were being served notices under the special revision of electoral rolls in the state, reported PTI. There is no controversy over the special revision. The Chief Minister was quoted as saying by the news agency, which Hindu has got notice, which Assamese Muslim has got notice. Notices have been served to Mias and such people, else they will walk over our heads. Mia is a derogatory term for Bengali-speaking Muslims. The ruling Bharatiya Janata Party has often labeled the community as infiltrators who are allegedly taking over resources, jobs, and land. On December 27th, etc., the Election Commission, now kindly come overleaf to the next page, let's. About para 4 on Saturday. I'll also have the fourth para at page 193, 193 minutes. Yes. On Saturday, Sharma stated that there was nothing to hide, reported PTI. We are giving them trouble, said the Chief Minister, referring to his earlier statement that Mias would face problems in his regime, according to the news agency. He added that serving them notices as part of the special revision exercise was a way to keep them under pressure. They have to understand that at some level, people of Assam are resisting them, said the BJP leader. Otherwise, they will get a walkover. That is why some will get notices during SR, some for eviction, some from border police. Sharma added, we will do some utpat, mischief, but within the ambit of law. We are with the poor and downtrodden, but not those who want to destroy our jati. This came a day after the Assam Congress and Rajor Dal chief filed separate complaints with the police against the BJP for allegedly attempting to tamper with voter lists. And so, in a complaint. And then, Lords, at page if this was 193, now your lordship may come to page 198 on 27th of January 2026. The chief minister stated that 4 to 5 lakh Mias will get deleted in the Assam SIR, and my job is to make them suffer. He says, in the second para, Assam chief minister on Tuesday claimed that 4 to 5 lakh Mia voters will be deleted when the special intensive revision of electoral rolls takes place in the state, and said that his job is to make them suffer. And then he says, vote chori, etc. The third para, he added, we have made arrangements so that they cannot vote in Assam, but this is preliminary. When the special intensive revision comes to Assam, 4 to 5 lakh Mia voters will have to be cut. And can I just read the para above that? What vote chori means to us, Sharma asked while speaking to reporters. Yes, we are trying to steal some Mia votes. Ideally, they should not be allowed to vote in Assam. They should be able to vote in Bangladesh. This time, I'm the pains to point out this is a dog whistle, because it is not.
Mr. Singh, you have made that point clear. We have read that's all right. But then each and every statement, they don't collocate with the earlier statement. And what vote chori? Why do you call it chori? We are not going to do it. We want to steal votes. These appear to be blusters. Anyway, but otherwise, other statements, of course, you can say, but not every part of it. So there is a Physiparis tendency, it appears from your showing. Let's see what they have to say.
Now, just 2 more letters, if I can show your lordship's notes. On page 202,
so 199, if you can show.
202 is very important, because here is an actual call for violence virtually against an entire community. At 202, your lordship will find 27 January and 28 January, the Wire reported that in a rickshaw, if the fare is ₹5, give them 4. The chief minister said, in a rickshaw, if the fare is ₹5, give them 4. Assam chief minister urged people to trouble the Mias. Just below that, Assam chief minister on Tuesday, January 27th, said that between 4 to 5 lakh Mias would be removed from the SIR. He also underlined that Himanta Biswa Sharma and the BJP are directly against Mias, and urged people to trouble the Mias, saying only if they face trouble will they leave Assam. Addressing reporters on the sidelines of an official event in Digboy in Tinsukia, Sharma asserted that it was his responsibility to cause hardship to the Mia community, a term commonly used in Assam to refer to Bengali-speaking Muslims in a derogatory sense. Vote chori means we are trying to steal some Mia votes. They should ideally not be allowed. This is a repetition. On the next page, the second para, your lordship may see, let Congress abuse me as much as they want. My job is to make the Mia people suffer, he said. And then your lordship will see whichever complaints have been on my orders. I myself have told the BJP people that they should keep giving complaints against Mias. There's nothing to hide about this. I have held meetings. I have done video conferences, that I've told people that wherever possible, they should fill Form 7s so that they have to run around a little, are troubled, so that they understand that the Assamese people are still living. If the Congress has objections, so be it. He added, whoever can give trouble in any way should give, including you. In a rickshaw, if the fare is ₹5, give them ₹4. Only if they face trouble will they leave Assam. These are not issues. He said, what is the point of telling us that these are issues? We are saying it openly. We are not hiding it. Earlier, people were scared. Now, I myself am encouraging people to keep giving trouble.
So saying it's about the same incident. We have seen it. Yes. Now,
but it's very explicit, the explicit call. And what Dr. Singhvi showed your lordship, a video of a rickshaw puller being actually harassed. That came immediately after this. Right after these statements were made, one lady harassed a rickshaw puller and refused to pay him for the. Now, my lords, if your lordships lastly just see, from 218 onwards, I've set out that same video, but what we did was we set it out in stills. From page 218 to 220 are the still pictures of what Dr. Singhvi has already shown, my lords. Now, my lords, if your lordships are kind enough just to come to my compilation, and I'll very quickly run through 3 or 4 judgments on hate speech and then the orders which we are praying for, lords. Yes. If my lord, I have got a brief compilation of some 5 judgments, and my lord may first take the Vasi Bhalai Sangathan, which your lordship will find is at page 6 of the compilation, 2014-11 SCC 477.
Yes.
My lord, that page 6. Now, yes. Lord, that para 8 of the judgment at page 14, the Supreme Court made an effort to try and cull out what is hate speech in the context of the Indian constitutional scheme. Para 8, hate speech is an effort to marginalize individuals based on their membership in a group, using expression that exposes the group to hatred, hate speech seeks to delegitimize group members in the eyes of the majority, reducing their social standing and acceptance within society. Hate speech therefore rises beyond causing distress to individual group members. It can have a social impact. Hate speech lays the groundwork for later broad attacks on vulnerable that can range from discrimination to ostracism, segregation, deportation, violence, and in the most extreme cases to genocide. Hate speech also impacts a protected group's ability to respond to the substantive ideas under debate, thereby placing a serious barrier to their full participation in our democracy. Then para 11, their lordships identified that where hate speech intersects with the criminal laws of the country. Para 11, given such disastrous consequences of hate speech, the Indian legal framework has enacted several statutory provisions dealing with the subject, which are referred to as under, and their lordships set out several sections of the Penal Code, the Representation of People Act, the CRPC, the Protection of Civil Rights Act, Religious Institutions Act, etc., which intersect with hate speech. Para 12, their lordship says, in addition thereto, the central government has always provided support to the state governments and union territory administrations in several ways to maintain communal harmony in the country. And in case of need, the central government also sends advisories in this regard from time to time. However, in such cases, as police and public order being a state subject under the 7th schedule, the responsibility of registration and prosecution of crime, including those involved in hate speeches, primarily rests with the respective state government. Then paras 15 and 16 may just be seen at page 16 of the compilation. Sections 153A and 153B IPC make any act which promotes enmity between the groups on grounds of religion and race, etc., or which are prejudicial to national integration, punishable. The purpose of enactment of such a provision was to check falciparas, communal and separatist tendencies and secure fraternity so as to ensure the dignity of the individual and the unity of the nation. Undoubtedly, religious freedom may be accompanied by liberty of expression of religious opinions, together with the liberty to reasonably criticize the religious beliefs of others. But as been held by the courts time and again, with powers come responsibility. Section 295A IPC deals with offences related to religion and provides for punishment up to 3 years for speech, writing, or signs which are made with a deliberate and malicious intent to insult the religion or religious beliefs of any class. This court in Ramji Lal versus State of UP has upheld the constitutional validity of the section. Similarly, 298 IPC provides that any act with a deliberate and malicious intention of hurting religious feelings is punishable, 295A, etc. Now, if my lord would come to Amish Devgan, which is at page 20 of this compilation. Now, this was arising. I'm sorry.
You can mention that the provisions are now 196 and 197 of BNS.
Yeah, that's in our prayer.
The same provisions.
Look, these provisions of the IPC have now been replaced.
Just a minute, Mr.
Well,
It can be operationalized. Yes.
So, the provisions which are referred to in Pravasi Bhalai of the IPC, etc., are now replaced in the BNS. And in our prayers, we have identified all the current provisions also. Now, if my lord would just come to Amish Devgan, that page 20 of the compilation, that is 2021, 1 SCC page 1. This arose from discharge applications in multiple complaints against a TV personality. Please just come to para 75 at page 85 of the compilation, where the court spoke about the context in which different speakers can speak and how when an individual or a villager or somebody speaks, it's taken with a pinch of salt. Please see para 75 at page 85. The context as indicated above has a certain key variable, namely who and what is involved and where and the occasion, time and under what circumstances the case arises. The who is always plural, for it encompasses the speaker who utters the statement that constitutes hate speech and also the audience to whom the statement is addressed, which includes both the target and the others. Variable context review recognizes that all speeches are not alike. This is not only because of group affiliations, but in the context of dominant group hate speech against a vulnerable and discriminated group, and also the impact of hate speech depends on the person who has uttered the words. The variable recognizes that a speech by a person of influence, such as a top government or executive functionary, opposition leader, political or social leader or following, or a credible anchor on a TV show, carries a far more credibility and impact than a statement made by a common person on the street. Latter may be driven by anger, emotion, wrong perceptions, or misinformation. This may affect their intent. Impact of their speech would be a mere indifference, meet correction criticism by peers or sometimes negligible to warrant attention and hold that they were likely to incite or had attempted to promote hatred, enmity, etc. between different religious, racial, language, or regional groups. Then kindly come down to placitum, between just 2 lines above placitum D, Millers. Likelihood of similar, about 2 lines above placitum D on that page, likelihood of similar statutory mandate to violence, public disorder, or hatred, when satisfied, would result in penal action as per law. Every right and indulgence has a limit. Further, when the offending act creates public disorder and violence, whether alone or with others, then the aspect of who and the question of indulgence would lose significance and may be of little consequence. Persons of influence, para 76, persons of influence keeping in view their reach, impact, and authority they wield on general public or the specific class to which they belong, owe a duty and have to be more responsible. They are expected to know and perceive the meaning conveyed by the words spoken or written, including the possible meaning that is likely to be conveyed. With experience and knowledge, they are expected to have a higher level of communication skills. It is reasonable to hold that they would be careful in using the words to convey their intent. And then, that para 114, if my lords come to page 101 of the same report, page 101 of this compilation, para 114 of the same report. In Lalita Kumari, a constitution bench of 5 judges of this court has held that section 154 of the CRPC in unequivocal terms mandates registration of FIR on receipt of all cognizable offences, subject to exceptions in which case a preliminary inquiry is required. The petitioner has not contended that the present case falls under any of such exceptions. Conspicuously, there is a distinction between arrest of an accused person under section 41 of the CRPC and registration of the FIR, which helps maintain delicate balance between the interest of society manifest in section 154 of the CRPC, which directs registration of FIR in case of cognizable offences, and protection of individual liberty of those persons who have been named in the complaint. The Constitution Bench, referring to the decision of this court in Tappan Kumar Singh, reiterated that FIR is not an encyclopedia disclosing all facts and details. The informant who lodges the report of the offence may not even know the name of the victim or assailant or know how the offence took place. He need not necessarily be an eyewitness. What is essential is that the information must disclose the commission of a cognizable offence, and the information must provide basis for the police officer to suspect the commission of offence. Thus, at this stage, it is enough if the police officer and information given suspects, though he may not be convinced or satisfied that a cognizable offence has taken place. I'm only citing this to say Lalita Kumari has been followed with mandates the registration of offence. Now, your lordships in the Supreme Court have gone further and said that when hate speech is made, especially by responsible people, there is a suo motu requirement by the police to register. There's a mandate that they have to register an FIR. They cannot hold their hand back and wait for a complainant to come forward even. That is, if I'll just place straight away judgments in that regard. Now,
Shaheen Abdullah,
in Shaheen Abdullah, which Dr. Singhvi has placed before your lordships, takes that view, and Millards also
that's separately handed over by our colleague.
In Ashwini Kumar Upadhyay.
Yes.
Learned counsel who's present in court will hand up to your lordships was the order in Ashwini Kumar Upadhyay,
2023.
which is the Supreme Court's order on 13th of January 2023.
Page 8 of the order.
And after a long title, etc., at page 8, is in our compilation.
It's been handed over to them.
Right. At page 8, your lordship will see where the order begins. Issue notice, petitioner will serve stand. Additional respondents shall ensure that immediately as and when these additional respondents notice had been added on the direction of the court, all states were given notice and had been added as additional respondents. Additional respondents shall ensure that immediately as and when any speech or any action takes place which attracts offences such as 153A, 153B, and 25A and 505 of IPC, etc., suo motu action will be taken to register cases even if no complaint is forthcoming and proceed against the offenders in accordance with law. Additional respondents will therefore issue directions to their subordinates so that appropriate action in law will be taken at the earliest. We make it clear that any hesitation to act in accordance with this direction will be viewed as contempt of this court and appropriate action will be taken against the erring officers. We further make it clear that such action will be taken irrespective of the religion that the maker of the speech or the person who commits such act belongs to, so that the secular character of Bharat as is envisaged by the preamble is preserved and protected. So, and then in Tehseen Poonawalla, that's not in our compilation. Tehseen Poonawalla will be handed up to your lordships, lords. Para
40. CC version. It is para 40. It is para 40 or 40.10.
Look, para 30 may kindly be seen. Para 40 of Tehseen Poonawalla, which has been handed up to my lord, at page 527. 520. The directions issued by the court. This arose from lynching incidents and other mob violence, all kinds of incitement to mob violence, and preventive measures were laid down by the Honorable Supreme Court from page 525 onwards.
40.10.
And in these preventive measures, if my lord would see 40.10 at page 526.
Also the next one.
Duty of the central government and the state governments.
Yes, it shall be the duty of the central government as well as state government to take steps to curb and stop dissemination and irresponsible and explosive messages, videos, and other materials on various social media platforms which have a tendency to incite mob violence and lynching. And the police shall cause to register FIR under 153A and other relevant points of law against persons who disseminate irresponsible and explosive messages and videos having content which is likely to so and so. And then on remedial measures also there.
Yes.
We need not go into that. And then, my lords, in regard to these sort of statements like what is being done about this jihad, that jihad, etc., kindly just see the order of the Supreme Court in Firoz Iqbal Khan, which is at page 1 of this compilation. There was a series of television programs called UPSC Jihad, and Job Jihad, etc. And at para 11 on page 4 of the compilation, their lordships set out the court is presently seized with hearing of the writ petition, which will continue on the next available date. This was the previous order passed. And then their lordships noted, just see para 11.
The last one.
It does appear that the intent.
And if your lordship sees on page 4 of this compilation from Placidum G, there is no relaxation either in the age limit or in so and so. The drift, tenor, and content, last 2 lines on page 4, the drift, tenor, and content of the episode is to bring the community into public hatred and distribute. The court is duty bound to ensure compliance with the salutary principles of the program code. Then para 13 and 14, the edifice of a democratic society committed to the rule of law under a regime of constitutional rights, values, and duties is founded on the coexistence of communities. India is a melting pot of civilizations, cultures, religions, and languages. Any attempt to vilify a religious community must be viewed with grave disfavor by this court. As the custodian of constitutional values, its duty to enforce constitutional values demands nothing less. Conscious, therefore, as we are of the previous order dated so and so, declining to issue a pre-broadcast injunction, we are of the view that there has been a change of circumstances, at least prima facie, on the basis of the record which has emerged before this court. On 28th August, this court was truly in the realm of a pre-broadcast injunction when even the first program was to be aired. Since then, episodes have been aired between so and so, which indicate the content, tenor, and object of the telecast in question. The remaining episodes, admittedly, will be in the same vein. On the basis of what has been aired, we are of the view that it will be necessary to interdict any further telecast. Consequently, we direct that pending further orders, the fifth respondent shall stand injuncted from making any further telecast in continuation of the similar thing. So all those job jihad, UPSC jihad, etc. came to be injuncted.
Section 27 is covered with Jaising in a petition.
And in our petition itself, we have annexed 2 or 3 orders, which your lordship may be kind enough to see, Millard.
Page 229.
At page 221 of the main the PIL petition is the order of the Honorable Supreme Court dated 19th May 2025 in Kumar Vijay Shah versus the High Court of Madhya Pradesh. Here, Milord's, remarks had been made by a minister in the state of Madhya Pradesh against the particular and the Supreme Court, Milords, directed that an SIT be set up at para 3 of the order at page 222, Milords. Sorry, para 4. Having gone through after saying that they were already before the court, having gone through the contents of the statement attributed to the petition and also the contents of the apology purported to have been tendered by him, we are satisfied that the subject FIR requires to be investigated by a special investigation team. Such SIT shall comprise of 3 senior directly recruited IPS officers of the Madhya Pradesh cadre, but who otherwise do not belong to the state of Madhya Pradesh. We are further of the opinion that out of the 3 officers, one should be a woman IPS officer. The DG of police is directly to constitute the SIT by 10 a.m. SIT shall be headed by an officer not below the rank of IGP, and the remaining 2 members shall also be in the rank of superintendent, etc. And then the Lordship will see an order which was in the case of stampede which took place at page 229. The Tamila Vetri Kalagam, there was one actor who had started a political party and it led to some stampede, etc. The order is at page 229, but my lord may come straight away to page 248, para at page 248. Looking to the fact that the issue involves certainly has a bearing on the fundamental rights of citizens and the incident which has shaken the national conscience deserves fair and impartial investigation. As such, by way of interim measure, direction deserves to be issued to hand over the investigation to the CBI, which would lead to fair administration of justice.
Impartiality.
And then, my lords, at para 33, in the facts of the case, and the prayer is made in order to allay the concerns of all persons in pursuit of independence and impartiality of investigation, we propose to set up a 3-member supervisory committee headed by a former judge of this court. We have requested Honorable Justice Ajay Rastogi, who has agreed to head the said committee. We further request him to choose 2 senior IPS officers, not below the rank of IGP, who may be of Tamil Nadu cadre, but shall not be a native of Tamil Nadu as per the choice of the learned former judge. Scope of mandate of the committee, etc. We are not really concerned with that. And then, my lord, that page 224 is the judgment of the Supreme Court in the violence which took place in Lakhimpur Kheri. And at page 226, this order, my lord, that 224 was on 7th of November 2021. And at page 226, your lordship will see para 7 and 8. I'm sorry, my learned friend wants me to read para 5 at page 225. This court is equally concerned about guaranteeing an impartial, fair, just and thorough investigation into the incident which has resulted in such a tragic loss of life of protesters. Then para 7, this court in Babubhai Jamnadas Patel has delineated the purpose of the judiciary in such circumstances and noted that the Supreme Court and the High Courts are the sentinels of justice that ensure that the rule of law and constitutional guarantee of a fair and impartial investigation into alleged criminality are upheld on several prior occasions, including in Bharati Tamang versus Union of India, Zahira Habibullah Sheikh versus State of Gujarat. Steps have been taken by courts for monitoring the investigation of alleged criminal offences. While investigating such offences, justice must not only be done, must also be seen to be done. We thus deem it appropriate to reconstitute the SIT to preserve the faith and trust of people in criminal administration of justice. Further, to assure full and complete justice to the victims of crime, we are inclined to order that the ongoing investigation be monitored by a retired High Court judge, who too may not have his roots in the state of Uttar Pradesh. We therefore appoint Justice retired Rakesh Kumar Jain, a former judge of the Punjab and Haryana High Court, to monitor the investigation, etc. So there are, I don't want to multiply it, there are several other orders and so on. If my lords are kind enough just to come to my prayers straight away,
Yes.
At page 87, the first 3 prayers and the last 2 prayers are more general in nature. And then there are certain prayers which deal with the criminality aspect. But I'm very anxious, my lord, that your lordships take cognizance of the first 3 prayers in particular, because we are very concerned, Lord, not with securing punishments and so on, but with securing peace and harmony in our state, Lord. We are people who, as I gave in the preface, Lord, we are very deeply concerned about a state. One of us is in his late 80s, one is in his late 70s. We have lived our entire life there. We are concerned that we don't want to see our state going up in flames, Lord, that has happened in a neighboring state of Manipur and so on. We want, Lord, peace to be there. So please just see the prayers, Lord, 1, 2, and 3. Mandamus, Lord, directing respondent 3, his agents, etc., to completely refrain from indulging in speech that instigates the social or economic boycott of any minority community in Assam or driving out of any minority community from Assam. Issue an order directing the respondent 3, etc., to completely refrain from inciting civilians to take law and order into their own hands by acting against persons perceived to be of a minority community. Mandamus Lords to completely refrain from indulging in speech that promotes enmity, hatred, and ill will towards a community based on religion and language. Now, 4 and 5 are, my lords, with regard to criminal. 4, 5, and 6 are with regard to, my lords, criminal investigation, where we are seeking, my lords, we are praying that the court may, after notice, of course, constitute a proper SIT, my lords, headed by a retired learned judge, and with some sort of guarantee of impartiality, which is under the supervision of the court.
Yes.
Now, please see prayer 7, Lord. Issue a declaration that respondent 3 has committed a violation of the oath of office under Article 164(3), read with the preamble. The oath of office we have set out, Lord, at page 48 of our petition. And
this, I'm sure you'll say only after notice.
Certainly after notice, Lord. Today we are really praying, Lord, that your lordships issue notice and that my lords give some indication that this must stop. This can't go on, Lord. We are facing a very distressing situation. I can't say anything more than that. It is exceedingly distressing that, Lord, the head of the state, who has such great responsibility to serve all the citizens of the state, should pick and choose between citizens. It's just very distressing, to use demeaning language, to denigrate people who are, after all, every single citizen of the state has an expectation from our chief minister.
All right.
So,
Yes.
the interim prayers are set out at page 90.
Let's hear out.
Well, I just could flag that page 90 are the interim prayers. I am deeply obliged.
दोस्तों, ये थी सीनियर एडवोकेट की धारदार दलीलें, जिन्होंने न सिर्फ अदालत के भीतर हलचल मचा दी, बल्कि देश के लोकतांत्रिक भविष्य पर भी कई सवाल खड़े कर दिए हैं। सिंह साहब की ये बातें हमें याद दिलाती हैं कि संविधान की रक्षा केवल किताबों से नहीं, बल्कि सही समय पर उठाई गई आवाज से होती है। अब सवाल यह है कि क्या इन दलीलों का असर आने वाले फैसलों पर भी दिखाई देगा? क्या सत्ता की जवाबदेही तय हो पाएगी? आपकी इस बारे में क्या राय है? आपको क्या लगता है किसी खास समुदाय के खिलाफ टिप्पणियां करना हमारे लोकतंत्र को कमजोर कर रहा है या नहीं? अपनी कीमती राय कमेंट्स बॉक्स में ज़रूर लिखें। अगर आपको ये जानकारी महत्वपूर्ण लगी हो तो वीडियो को लाइक और चैनल को सब्सक्राइब करना ना भूलें। जय हिंद दोस्तों।